Hi aspirants. In this model, we are going to discuss a very interesting IPR classification, copyright. As we know, patent protects your innovative ideas, whereas copyright protects your expression of ideas. You can express your creativity by many ways. By words, that's nothing but literature, novel, books. By music, by sound, by cinema, by sculpture, by architecture, by paintings, by photograph. In so many ways, you can express your creativity. You can get legal protection for those expression also. That's nothing but copyright. Copyright provides legal protection for your expression of ideas or expression of creativity. How it is? Let's discuss about this. What is copyright? Copyright is the author's right. It is a legal term used to describe the rights that creators have over their creative works. Any copyrighted work can be identified with a symbol that is C. If you see the book with the symbol of C, you can understand that the book have copyright protection. The copyright is usually for a limited time. There are two types of copyright. The first one is the economic right. Another one is the moral right. Economic rights which allow the copyright owner to derive financial reward from the use of their works by others. When other people use their creative works, the copyright owner will get some financial reward. That is nothing but economic rights. Moral rights protect the non-economic interest of the author. Here we are using two terms, owner, author. That is the difference between ownership of the copyright and the authorship of the copyright. Who is the owner of the copyright? The Indian Copyright Act 1957, Section 17 defined the first owner of a copyright. Who is the owner of a copyright? The author of a work shall be the first owner of the copyright. So he has the rights, economic as well as the moral rights. Author of the copyright. The term author is very important because many litigation cases were filed and many litigation cases are ongoing because of the confusion between the authorship of the copyright and the ownership of the copyright. As we discussed before, Section 17 says the author of the creative work is the first owner of the copyright. Then we need to understand who is the author of that particular creative work. Section 2D in the Copyright Act 1957 defined the term author. Author means in relation to a literary or dramatic work. The author of the work, the writer of literary or dramatic work is the author of the work. Then he is the first owner of the copyright. He has the legal protection. In relation to a musical work, the composer is the author of the work. He is the first owner of the copyright. In relation to an artistic work other than a photograph, the artist is the first author of the creative work. So he is the first owner of the copyright. In relation to a photograph, the person taking the photograph is the author. So he is the first owner. In relation to a cinematographic film or sound recording, the producer is the author. So the producer is the first owner of the copyright. It's very important. In relation to any literary, dramatic, musical, or artistic work which is computer generated, the person who causes the work to be created, so he is the author, so he is the first owner of the copyright. Copyright provides legal protection for creative work. Creative works are so many. We need to understand which type of creative work can get copyright protection. For that purpose, we need to understand the term work. Section 2Y, the Copyright Act 1957 helps us to understand the term work. Define the term work. Work means any of the following works, namely a literary work, dramatic work, musical or artistic work, a cinematograph film, a sound recording. So these are the type of creative works can get copyright protection. So what type of literary works can get copyright protection? Work of fiction, novels, technical books or paper, biography, dramatics, thesis, script, research work, compilation, tables and computer programs, computer databases. So these are the literary works can get copyright protection. Further, Section 2O, the Copyright Act 1957 defined the literary work. Literary work includes computer programs, tables and compilations, including computer databases. The present slide shows the list of works under dramatic works can get copyright protection. Any arrangement of acting a play or a part of recitation work a part of choreographing work, a part of dumb show entertainment, a picturesque arrangement, acting work based on a fixed writing work, but it do not include cinematograph films. So these are the works under this dramatic works category. We can get copyright protection. Section 2P Copyright Act define musical work. What kind of works coming under musical work? Musical work means a work consisting of music and includes any graphical notation of such work, but doesn't include any words or any action intended to be sung, spoken, or performed with the music. Sound recording, there is a difference between musical work and the sound recording. Section 2XX defines this term sound recording. Sound recording means a recording of sounds from which such sounds may be produced, regardless of the medium on which such recording is made or the method by which the sounds are produced. Any type of medium you can use for recording. Any type of method also you can use for production of sounds, but it is nothing but recording of sounds. It is a fixation of series of sounds that doesn't accompany an audio-visual work. So this includes beats, percussion, bass, guitar, vocals, etc. So this is sound recording. Artistic work. Section 2C defines this term artistic work. Artistic work means a painting, a sculpture, a drawing, including a diagram, map, chart, or plan, an engraving, or a photograph, whether or not any such work possesses artistic quality. So for this type of work, artistic quality is not required, but still you can get copyright protection. A work of architecture and any other work of artistic craftsmanship. Work of architecture, work of sculpture, they can also get copyright protection. Section 2B define work of architecture means any building or structure having an artistic character or design, or any model for such building or structure can get copyright protection. Section 2ZA defined work of sculpture includes cast and models. Cinematography, we know very well. Cinema is a very interesting entertainment creative work. We can get copyright protection for this also. Section 2F define this term. Cinematograph film means any work of visual recording and includes a sound recording. That's called cinematograph film. It includes video films also. Performer can get copyright protection. Who is performer? Section 2QQ define the term performer. Performer includes an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. They are called performer. Performance. Section 2Q defines this term performance in relation to performer's right means any visual or acoustic presentation made live by one or more performers. In this slide, we are going to discuss what are the exclusive rights associated with different types of works under copyright protection. Means you got a copyright protection for your literary work or dramatic or musical work, not being a computer program. Then what are the exclusive rights you have? You have the rights for reproducing the work in any material form, including the storing of it in any medium by electronic means. You can reproduce, you can store. You have the rights for issuing copies of the work to the public, not being copies already in circulation. You have the rights for performing the work in public. You have the rights for communicating the work to the public. You have the rights for making any cinematograph film or sound recording in respect of the work. You have the rights for making any translation of the work. You have the rights to make any adaptation or translation of the work. So these are the exclusive rights associated with literary, dramatic, or musical work under copyright protection. The exclusive right associated with artistic work under copyright protections are for reproducing the work in any material form, including the storing of it in any medium by electronic or other means, depiction in 3 dimensions of a 2-dimensional work, or depiction in 2 dimensions of a 3-dimensional work. Further, we have the exclusive right associated with artistic work under copyright protections are, we have the rights for communicating the work to the public. We have the rights for issuing copies of the work to the public, not being copies already in circulation. We have the rights to include this work in any cinematographic film. We have the rights to make any adaptation of the work. The exclusive right associated with cinematograph film under copyright protections are, we have the rights for making a copy of the film, including a photograph of any image forming part thereof, or storing of it in any medium by electronic or other means. We can sell or give on commercial rental or offer for sale or for such rental any copy of the film. For communicating this film to the public. So these are the exclusive rights we have when we have copyright protection for cinematograph film. The exclusive rights associated with sound recording under copyright protection are, we have the rights for making any other sound recording, embodying it, including storing it in any medium by electronic or other means, for selling or giving on commercial rental or offer for sale or for such rental any copy of the sound recording, for communicating the sound recording to the public. The present slide shows the Copyright Office in New Delhi. Another important creative work is musical work. We have discussed before the definition of a musical work. Once again, we recap the definition. Musical work means a work consisting of music and includes any graphical notation of such work, but doesn't include any words or any action intended to be sung, spoken, or performed with music. It's called musical works. So the very important question now, who is the author of the musical work? According to the section 2D, as we discussed before, the author in relation to the musical work is a composer. So who is the composer? Again, the section 2 FFA define the term composer in relation to a musical work means the person who composes the music, regardless of whether he records it in any form of graphical notation. Who owns music rights in India? The Indian Performing Rights Society, IPRS, handles the rights for lyricists and composers. Copyright society means a society registered under subsection 3 of section 33. Subsection 3 of section 33, what it says? The central government shall register only one copyright society to do business in respect of one class of creative works. When they register, few factors they will take into consideration. The first one, the interest of the authors and other owners of the rights under this act. Second, the interest and convenience of the public. Third, the groups of persons who are most likely to seek licenses in respect of the relevant rights. Fourth, the ability and professional competence of the applicants. After taking these factors into consideration, the central government registered such association of persons as a copyright society. Like example, Indian Performing Rights Society. So it is a non-profit copyright society comprising of authors, composers, and music publishers. So it is a copyright society for musical works. They are having members. They defend the interest of music copyright holders and ensure fair value for music. The chairman of this copyright society is Mr. Javed Akhtar. The present slide shows members of Indian Performing Rights Society, IPRS. Now we are going to discuss the functions of Indian Performing Rights Society, IPRS. It is a registered copyright society for musical copyright works. The function is, IPRS is to legitimize the use of copyrighted music by music users. IPRS issues licenses to music users to use the copyrighted music. IPRS collect royalties from music users for and on behalf of IPRS members. Who are IPRS members? They are authors, composers, and publishers of music. Royalty those collected by IPRS is distributed amongst members after detecting IPR as administrative cost. So these are the functions of Indian Performing Rights Society. Now we need to understand who are authors, who are composers, and who are the publishers of music. Composers are those who are better known as music directors. Authors are better known as lyricists. Publishers of music or the music companies are those who hold publishing rights of the musical and literary works. Authors and composers are sometimes referred as writers, which can mean any or both of them. The present slide shows the list of music copyright owners. So till now we have discussed about the musical work. Now we are going to discuss about the sound recording. It's another type of creative work. What is sound recording? Is sound recording often also referred to as a master? It is the recording of a performance of the underlying composition. This includes beats, percussion, bass, guitar, vocals, etc. The copyrights in sound recordings are customarily held by record companies, like example, Sony Music Entertainment, Warner Music Group, Universal Music Group. Now, who is the author of sound recording? The author of a sound recording work is the producer of the sound recording. Whereas in musical work, composer is the author of the work. Then who is producer? Section 2UU define the term producer. It is relation to a cinematograph film or sound recording, means a person who takes the work, the initiative and the responsibility for making, who takes the cinematograph film or sound recording work, the initiative and responsibility for making. He is the producer, he is the author of sound recording, so he is the first owner of the copyright. As we discussed before, central government register one copyright society for one type of creative work. So for sound recording, central government register one copyright society. In India, the Phonographic Performance Limited (PPL) handles the copyright of sound recordings. To play the recording of any song in the public space, one needs a permit from PPL. Functions of Phonographic Performance Limited (PPL). Before we see the functions, we need to understand under the Copyright Act 1957, every business entity or individual must receive permission from the copyright owners of the sound recording before any public performance takes place. PPL enforce the rights of PPL members by ensuring that businesses comply with the law and pay copyright holders for the music they consume. PPL is a non-profit organization and the royalties they collect are given to the rightful owners of the music. Now we are going to discuss how does the PPL licensing process work. Step 1. The sound recording company music labels. They grant rights to PPL India via assignment dates. Step 2. Businesses, establishments, venues, premises, event organizers, corporates, and or individuals. They contact PPL licensing executives and they purchase license for on-ground public performance. Step 3. PPL India collects royalties or license fees. Step 4. PPL India distribute the royalties to the music labels, sound recording company, after detecting the operating cost. So in this way, the PPL licensing process work. So aspirants, in this model, we have discussed many points about the copyrights. I hope it will be definitely helpful when you register your creative work under Copyright Act. Thank you so much.